Hello everyone, welcome to lecture 5 and I'm Dhriti Dharia. In today's lecture, we would be continuing with the topic of arrest. So in lecture 4, we had started off with the topics of summons and moved on to the topic of arrest with a warrant. Those were the two modes. There's another mode, obviously proclamation, etc., where you are trying to ensure the presence of an accused there. In today's class, we'll start off a bit with the leftover part of in respect of arrest with a warrant, and then we'll move on to arrest without a warrant and other such provisions. So as we know that arrest is quite an extensive and a long topic, so today's lecture might be a little long, so please bear with me. And without delaying any more, let's start off with today's topic. So if you can recall back lecture 4, there we had seen how the warrant is there, what is written in a warrant, who is it given, who executes a warrant, what is the duration, etc. There were two sections that I forgot to deal there. That was section 75 and 76. Section 75 there is saying that a person, whoever is executing the warrant, mostly it's a police officer, that person, whoever he is arresting, it is his duty to tell the person he is arresting that look, these are the reasons, this is the substance that has been written in the warrant for which I am arresting you, and if it is required, then he may also show the warrant to that particular person. And what does section 76 says? 76 is telling that this particular person who has been arrested has to be brought before a court without delay, subject to section 71. Here also you'll see the 24 hours limit that is so talked about. The 24 hours limit is there, and the time journey moving from the place where he's been detained to the court, that time is obviously excluded. So this was completing the arrest with a warrant part. Moving on to today's topic, that is arrest without a warrant. So this is one of the most important sections. A lot of questions gets frames here, that what are the situations in which can the person, police officer, arrest, like in an MCQ it can be given that can a police officer arrest a person who has done such and such event, can he arrest him without a warrant? Then you have to remember this section and remember. So here you would remember that we had dealt with the difference between a cognizable and a non-cognizable offense. In section 41 we are seeing that a police officer has been empowered with the powers to arrest without a warrant and without an order of the magistrate in certain cases. And what are those conditions? The first is that in presence of the police officer, somebody has committed a cognizable offense, he can arrest that person. Second situation, if there is a reasonable complaint or any credible information has been received, or there is a reasonable suspicion that a particular person against whom that complaint or information has been given has committed a cognizable offense. And what kind of a cognizable offense? Which is punishable with less or equal to 7 years of punishment with or without fine. Then in that case also he can arrest such a person, provided that the police officer has first a reason to believe that yes, this person might have committed it. Second, that the police is feeling that arrest is essential over here. Why? For these following reasons: so that further offense is not committed, or for the purpose of proper investigation his arrest is needed, or for preventing the tampering of any evidence, or that person is trying to induce, threat or promise somebody so that they do not come and disclose details, etc. Or if the police believes that without arresting him he could not be brought to the court, so in such a situation of less than or equal to 7 years, first he has to be having a reason to believe that he has done it, and then he has to see that the arrest is essential for these following one of the following reasons. Then what is the third situation where the person can arrest without a warrant? The police officer can arrest without a warrant where there's a credible information that they have received that a crime with a punishment greater than 7 years or punishable with death has been done, and the police has a full solid reason to believe that yes, it seems so that that only person has only committed such an offense. Then which is the next category? The next category is a proclaimed offender. And who declares a person as a proclaimed offender? It can be either the state government, or the declaration can be done under the court. Then which is the fifth category? The fifth category is that a person has been reasonably suspected of having stolen property, like he is receiving stolen property or keeping stolen property, and he is suspected that in relation to that property he is the one who has been committing that offense. Then what is the next category? If somebody is obstructing a police officer, he's doing his duty, or he's trying to escape, or he's attempting to escape from lawful custody, in that situation also arrest can be done. Then another is when there is a reasonable suspicion that a particular person has deserted the armed forces of the Union, any of the armed forces, that person can also be arrested on this ground. And if there is a reasonable complaint or credible info or any such sort of a thing that a particular act has been committed, even if it was not committed inside India, but if that act was committed inside India, it would have been an offense and he was liable to be extradited and apprehended in India, that person can also be arrested without a warrant. And then the last few things are there, that if a convict had been released and he is breaching the rules which are made under 356(5), then also you can arrest. And last, that somebody has received, that police officer has received a requisition of arrest from another police officer, and that particular offense for which he has to be arrested is an offense where this person can be arrested without a warrant. And so in these particular situations, a police officer has a power to arrest without a warrant. You see, in general, you need a warrant to arrest, but 41 is telling you the certain cases where without warrant or without the order of a magistrate, the arrest can be made. And one important thing, as you remember in the difference between cognizable and non-cognizable offense, for a non-cognizable offense, no arrest without warrant can be done. You remember that's the main distinction. So subject to section 42, for a non-cognizable offense, no arrest can be made under this section unless there is a warrant or an order of a magistrate is there. But in section 42, there is one situation where for a non-cognizable offense also a person can be arrested when then the person is refusing to give his name or residence where he is living, or he is giving false details, etc. Then the police officer can detain him so that he can ascertain those details. And when those details he gets, he'll release him with or without sureties, asking him that, look, you have to appear on this particular date before the magistrate. And here there is a small proviso, like for example, the person of the non-cog offense is there, his name and residence and all of that is a problem. Here, if you are taking sureties, you have to ensure that they are Indian, the sureties are Indian residents, because there may be chances that he is a non-resident and he still, again, even after all of that, he has given you false details and fled the country, and his sureties are also out of the country. The time you'll waste in pursuing that person and then trying to bring the sureties to the court, it will be of no use. Like, this entire provision of getting sureties would be futile. So that is why those sureties should be Indians. Then another thing is there, for example, you detain this person, but 24 hours have elapsed, you could not get anything out of it, or he has failed to execute a bond. What is your duty? You will take him to the nearest magistrate who has jurisdiction. Remember this, a police officer, if there is no warrant, you can only arrest till that 24 hours deadline is always running on their heads. Because if it exceeds that and you have no reasonable explanation, it becomes an illegal arrest. Now let's see another thing in relation to section 41. When you read section 41, you saw that there was a lot of powers that have been given to a police officer. But does this mean it is limitless? No, it is not limitless. It has certain limitations also. It has certain you can say there are limitations on this exercise of power. First, it is not a shall provision, it is a may provision. That is, the police is expected to exercise its discretion. For every situation, they should not go and arrest an officer. They should see whether it's essential or whether it is not, whether it is a reasonable complaint, credible information, is it a credible information, etc. All these things, this discretion part of the things obviously depends on the facts of the case, that whether it's reasonable, credible or not. Why do you need to do so? Why this is there, that they need to be cautious while exercising these powers? Again, the same thing. The liberty of a person is of a paramount importance. Just because you are trying that, if just for the sake of doing so, you should not arrest a person. Whenever you're exercising a power under section 41, you should see whether by arresting this person, I am serving the societal interest of like preventing an offender from doing further offense, etc. Or even without arresting, can the societal interests be balanced? You have to maintain that balance all the time. In Code of Criminal Procedure, you will see a balance of provisions. It's not only for the victim or for the prosecution, you'll also see provisions for the accused also. criminal procedure, here you are dealing with punishments. You're actually taking away somebody's liberty to an extent. Sometimes you are even taking away somebody's life. So, and you're doing it by a judicial process. So at all times you have to ensure that the balance is always there. You're not unduly doing anything. So this is a preface for the following sections that we'll cover also. Then what is section 41A saying? For example, in situations like, obviously it's a may provisions, the police officer may not decide to arrest a person. In that case, what should the police officer do? He'll issue a notice to those persons that, look, come before me, I have to make certain inquiries. Then what is section 41B saying? Now it is sort of a duty on the police officer that whoever is making his arrest, he should have his accurate, visible and clear identification, that his name should be there. When he is making an arrest, he'll make a memo of arrest. It will be attested by at least one witness. Who will be the one witness? Either his family member or any respectable member of the locality. This particular memo of arrest should also be signed by the person who has been arrested, and you have to also tell the arrested person that, look, you have the right to inform your family members if the person who is countersigning this memo of arrest is not his family member. I hope this is clear. You need to have a clear identification, prepare a memo of arrest, witness should be there to the memo of the arrest, arrested has also to sign the same. And if the countersigning is not a family, he should be there. Then what is 41C? It is talking about the control room that has to be established at the district and the state levels. And what is 41D? It is the right of an arrested to meet an advocate of his choice during integration, but not throughout the integration process. Here you can see the constitutional provisions also. One case law that you can see here is the Delhi Judicial Service Association with the state of Gujarat. I will not be dealing in detail with the case laws in this lecture series. I'll just give you the names of some of the most important case laws that I feel. I will not say that I'm giving a comprehensive list, that these are the only case laws that you need to cover. There may be a lot more, but these are some of the basics case laws that you should see. Like this particular case deals with the guidelines that were given to the police, that what should you follow while you are arresting a judicial officer. Then what do we see? That now we have seen the police having powers to arrest with a warrant, without a warrant. There can be situations where there is a need, there is no police officer around. Can a private person arrest a person? That has been dealt under section 43. So an arrest by a private person has been dealt over here, where it says that a private person may arrest or cause arrest of a person. Of what kind of a person? That person should have committed in his presence a non-bailable and a cognizable offense, or he should be a proclaimed offender. And after he has arrested that person, without delay, that private person should take the arrested person and make him over to the nearest police station or the police officer. And if the police officer there feels that, yes, this person that this private person has brought is somebody that they should arrest under section 41, they'll re-arrest him. If not, if they see it's a non-con offense and he's refusing to give his name, then you will arrest according to 42. However, if they see no sufficient reason that he has committed a particular offense, he'll be released at once. It is important in section 43 that the moment he arrests, simultaneously he should go and make over that person, because if he does not do so, a private person arresting somebody and not making him over to the police would be wrongful confinement. However, when a person, like for example, it's not always possible that a private person may become sure, I'm sure that this is an accused. He might make some mistake, a bona fide mistake, that he thinks that it is a cognizable or a non-bailable offense, so he brought him in there. There he gets covered by the exceptions clause of section 79 IPC. Then we see another kind of an arrest where the arrest is being done by a magistrate. Now, if there is an offense in the presence of any magistrate, judicial or executive, and it is happening within his local jurisdiction, he can himself arrest a person or order an arrest of an offender, and then subject to the other bail provisions, etc., he'll send him to custody. Now, this particular officer also has to, now this particular officer is arrested, he'll be sent to wherever he has to be. For example, a magistrate has arrested a person, does not mean that the same magistrate will try that particular case, because there is a conflict of interest, and an independence and an impartiality of a judicial officer or a magistrate is of paramount importance. So that particular case where an arrest has been done by a magistrate, though it wasn't within his jurisdiction also, still it will be tried by another magistrate, so as to ensure that it is an independent and an impartial process. Now, then there is section 45, where we are seeing that, where we are seeing the protection of the armed forces for the arrest. Here, whatever acts they have done in discharging the official functions, for that you cannot arrest them unless you take the consent of the required government. If they are under the center, take the center's consent, or the state, take their consent. So these are the 43, 44, 45. We are seeing private person, magistrate, and the armed forces persons. And 42 you see for a non-corp offense, and 41 is without a warrant, when you can do so. Then what do we see is section 46. Section 46 is important. Why? Here you are seeing how you are actually making an arrest. Like, what will you do? That will say that, okay, an arrest has been made. So for making an arrest, it is important that you actually touch or confine the person unless there is a submission on that from that person's side. In a case of a woman, you have to remember that even if she already submits, yes, I am ready to go along with you to the prison, etc., that is enough. It is presumed that the arrest has been made even though there was no touch, etc. Unless there are different circumstances and all of that, an officer arresting a woman should always be a woman. No other officer can touch a woman while arresting if that person is not a female. Now, if this particular person who's been arrested is resisting or is attempting to escape, the police officer has all rights to use any kind of means necessary to effect that particular arrest. They can shoot, etc. However, this particular right of using all such means does not mean that they can cause death. The right to cause death is only when that particular offense is punishable with either death penalty or life imprisonment. And another thing you can see under section 46 is that, except in exceptional cases, you cannot arrest a woman after sunset and below sunrise. Like the dark periods where the natural light is not there, you cannot do so. And if you really, there are special circumstances that you need that arrest of women or she'll escape or whatever, a woman officer will prepare a written report, submit to a judicial magistrate class 1 for permission, and this permission has to be taken prior to the arrest. So in case of a woman, you have to remember two things: the sunrise sunset provision, and the second thing, female officer only, and an oral submission is also enough. Then we are seeing section 47. Now just look at it logically. It is not possible that whoever I want to arrest, if I'm a police officer, I want to arrest, will be standing on the road or will be in an open space. There may be situations where that person is hiding inside a house or has run into a house. Does the policeman's power end as soon as the person not to be arrested has entered a private property? Obviously the answer cannot be no. So for that situation, you are seeing that if while pursuing him he has a warrant or he has an authority to arrest, some person has entered, he feels that he is inside a particular place. Now here, the person on whose property it is a doubt that the accused is there, he should give him, the police officer, the rights to get inside and give all the facilities available so that the police officer can do his duty. In case it is not being done and there are chances that the person will escape, the police officer has all the rights to use all force and break into the house, break any lock, window, entrances, doors, etc. And this authority to break in also includes break out. For example, if a police officer is chasing a particular accused person, has run into a house and somebody goes and bolts the door from outside, does not mean that the police officer only had the right to get in. He also has a right to get out. Like he can break the door and get out also. However, as we remember, if you can remember CPC or etc., whenever you were doing a search and all of that, if there's a Pardanasheen woman or a woman who does not come out in the public, etc., you have to give her time to take a recluse, take a side withdrawal, etc., and then only you can break in. Like, look at it logically. You're not allowing arrest is always with a warrant unless specified or is a non-cog offense. What are the situations in which a private person has been given that right to arrest or a magistrate has been given that right to arrest? How you are exempting an armed force officer, they all are backed by logic. It's not just merely placed there. Now I hope that was clear. I just digressed a little bit, but let's move on to section 48. Now section 48 is saying, again, you see, if I have gotten a warrant that I can For example, arrest a person who is located within my jurisdiction. He runs out of my jurisdiction. Does it mean that the moment my local limit finishes, I cannot pursue him? It does not mean that. Section 48 says that he has a warrant, or if he has if he has a purpose of arresting without warrant, he can pursue him all throughout India, and he is authorized to arrest that person. He can pursue him all throughout India. And section 49 is just saying that when you have arrested a person, if just merely holding his hand, leaving a tight grip on his hand is enough to restrain him, that's all. Do not exceed your powers. Do not use more force than is necessary to prevent his escape. That's all. Then what is section 50? Section 50, you are seeing from the rights of the accused sort of a thing, where the person who has been arrested without a warrant needs to be given all full particulars that of the offense that he has been accused of, whether he has a right of bail or not. If it is a non-bailable offense, and if he is entitled to a bail, he is entitled to be released on bail, then you have to let him know that these are the sureties that you can give instead of being arrested. And then what is section 50A? Here it is an obligation of the person who is arresting that, look, you have the right to inform any of your family or friends members, and this particular thing is a duty on the police, because you need to be informing that person, and whether you have informed or not, you have to put it down in a register, and this register will be shown to the magistrate, whoever is looking after the case. He'll check whether this compliance has been done or not. He'll ask the arrested also whether you were told that yes, I have a right to inform my family members, etc. All these provisions that you see related to rights of arrested, etc., are somewhat byproducts that have come out from the various case laws that the Supreme Court saw. There was situations of misuse, police torture, custodial violence, etc., which require that the code also has such provisions, so you are seeing them here. Then what is happening under section 51? If a person has been arrested with a warrant and he has no right of bail, or he has a right of bail but he is not able to furnish bail, or he has been arrested without a warrant, or he was arrested by a private person, he was made over to the police and the police decided to arrest him. Now no bail has to be given to him. Then after his arrest, what you'll do? First you'll search him throughout. You'll check whether he has any kind of objects, etc. Except his wearing apparel, you will take all other objects, you will seize it and take in their possession. Whatever you are taking away from his person, you have to write down a receipt and show it to that person. That person will keep that these are the items that I had on myself at that point of time, which are now with the police. And again, to remember, if you're searching a female, decency has to be maintained, and obviously another female only should do so. Then is section 52. This is 51 was the police officer's part to do this kind of a search. 52 is if he's carrying some offensive weapons, etc. This, whatever was seized by the person, has to be delivered to the court wherever he'll be produced that, look, this was what he's carrying. Here you have to remember, 51 only the police is doing the general full body search and all of that. 52, if there's an offensive weapon and a private person was the one who was arresting it, he can also take that. He can also seize that offensive weapon. Okay. Obviously, he has to make it over to the police station later on. Then is section 53. Section 53, you are seeing here, what are we doing? Here by this section, we are seeing that the police officer, you're aiding the police officer in having more evidence. Like the police officer feels that it is a particular offense where medical examination of an accused will give more reasonable evidence or grounds, etc., as in relation to the commission of the offense. Then they can ask a registered medical practitioner, etc., that please do so and prepare a report. And for this purpose, for this examination, reasonable force can be used. And obviously, if it is female, the practitioner, medical practitioner should also be taken care that as much as possible should be a female practitioner only. Here you can see the explanation, what does examination mean and all of that. Then in section 53A, where we see such an examination for a specific offense. For example, an accused of a rape or an attempt of rape, here where there are chances that you'll get certain evidence here, you will a registered medical practitioner in a government hospital or in a local authority hospital. If there's no such hospital within 16 kilometers of the offense that has been committed, any other registered medical practitioner can do such an examination, and who will request police officer not below the rank of sub-inspector, etc. And for here also, same way, reasonable force can be used for such an examination. Then when the report is prepared, after this examination is done, immediately report has to be prepared. It will have details like name of the person who bought him, what is his address, what is the name of the person examined, his address, his age, what are the marks of injury, what are the materials taken for DNA profiling. All these particulars in reasonable detail have to be put down in the report. And in the end, the person should also state down the conclusion that he has arrived at clearly. He made a full-on big report that this was there, this was there, this is there, but he did not come to a conclusion. That is not the case. He has to come to a conclusion. He also needs to record the time when he actually started examining the person and the time when he completed that there. And this particular thing has to be given to the IO, and this IO will take it, that is the investigating officer will forward it to the magistrate as a part of the 173 police report, which we will deal later on. In this particular section, we will see that an important case law of State of Bombay versus Kathukaogar. Here you are seeing the constitutionality of section 53 was challenged on the basis of Article 23. What is Article 20? Clause 3, which was dealing with self-incriminatory evidence nobody will be forced to allow. So he went up and said that this examination that you are doing and taking body samples, bodily fluids, etc., and trying to gather evidence is contrary to Article 20, Clause 3. However, the court had held that this privilege that is there in Article 20 is only limited to oral and written testimony and not such medical examination. You can go into it in detail. I already told you I'm not going into depth with the case laws. Then you are seeing section 54, examination of an arrested person by a medical officer after arrest, and here also female by female. This section under section 54 that medical examination is taking place is for the arrested. It's not for the police benefit. 53A was for the police benefit. 54 is for the arrested's benefit. So that when he is arrested, medical examiner will see whether he has been any injury marks, violence marks are there. He'll make a record of all of it. This particular copy will also be given to the accused or his nominated person, so that this particular report will be there if in case something happens, a custodial death happens, etc. That report of that medical practitioner would be there that look, when I examined him, these were the sort of marks that I found, and if he was staying in jail for so long and these are the type of marks that I am seeing, this means that something happened. Or for example, when he was arrested, he had no such marks, and later when he died, he had so many marks. So obviously that raises a doubt or a suspicion. So this is for the arrested. This is a provision for the arrested. Then you say section 54A, where you're talking about the TIP or the test identification parade. Identification of a person is needed by some other person or etc. is needed for investigation. Then remember, it's not the police. The court will grant such a permission. The police officer is conducting the TIP, but he cannot conduct it without the court's permission. So if it's a question relating to TIP, who conducts a TIP, etc., you have to take the name of the court. Mostly you have to take the name. You have to look at the wordings, but the court will cause such an identification to happen, not the police. The police can only request that please give me permission, please allow me to have such a, or please conduct such an identification, and this will be directed and conducted in whatever manner the court deems fit. And if the person who has been called to identify amongst all these persons, that person who has to identify is mentally or sick physically, this identification process needs to be in the supervision of a judicial magistrate. He'll take appropriate steps so that that particular person does not get disturbed. He is comfortable with whatever is being there, and this identification process needs to be video recorded. Then you see section 55. Section 55, you are seeing that it is not always possible that if an arrest warrant is directed towards a police officer, particular rank police officer, that please go and arrest. He is not the only work to go and look forward. Like for example, he has gotten, if a person of a high ranking police official has gotten information about a particular cognizable offense and he has a power to arrest without warrant, but he does not have the time to actually go and arrest that person, he can depute a subordinate. But for doing that, he'll deliver him an order of arrest. He'll specify that you have to arrest such and such person, for what reasons also will be written, and this subordinate will then inform whenever he is arresting that particular person, he will tell him about all of these things, and he can also show him the order. And this particular section will not affect his powers to arrest under section 41. That will always be there, but just this order should be there from the officer who has been deputed to his subordinate. Section 55A is again a pro-accused provisions where a duty has been passed on the person who is keeping the person in custody, that it is your responsibility to take care of his health and safety. Then 56 is saying that a person who has been arrested without warrant, he has to be taken before a magistrate without any unnecessary delay, obviously subject to the bail provisions. And in 57, you see the 24 hours clause coming, excluding the time of journey, etc. Then you see 58. What is there in 58? All the officers of police station, they require that whoever they have caught without warrant, whether they have given bail or not, they have to report it to a DM, or if a SDM is appointed in that regard, you have to submit a report in that case. Let's deal with section 59. 59 is talking about a discharge of a person who has been apprehended by the police. How will he be discharged? Either he furnishes his own bond, or he'll be given bail, or a magistrate has given him a special order. Remember this, his own bond, like you are, the police is allowing him to be released on his own bond or on bail or on under the special order of a magistrate. Then what is section 60? Section 60 is telling that a police has a power to escape. If somebody has escaped, they can pursue and retake a person. Here obviously section 47 will apply. That here section 7 will also apply. Now even if that particular person who's now running behind an escaped offender to arrest him again, here even though he's not under a warrant or he is not a police officer having authority to arrest, but still he can do so, because here it is a different situation where the person is trying to escape and you're trying to retake that person back. And section 60A is talking that an arrest should always be made strictly according to this code or any other law, whichever is in time being enforced relating to arrest. So this was all the provisions that were there in the code in relation to it, where you saw when you deal it with in continuation with section lecture 4, you saw the arrest with the warrant. Then you moved on to arrest without a warrant. You saw private person and all of them, the different other situations, who can be arrested, what can be arrested, what happens when you keep them together, and all of that was there. Now there's one small part left, but I think this will take a lot of time and it will increase the length of the class a lot. So we can do this in the next class that deals with the rights of arrested, that it will give you in one like we have already done with most of the rights of the arrested by dealing with the sections, but here I'll just crystallize it out and also add certain case laws. This we'll try on and move it for the next class. I hope this class is clear, and whatever we have dealt with arrest, because this is one of the essential and the most important parts in CrPC, and there are a lot of questions like for relating to, for example, you do go at questions on where has been the 24 hours limit being prescribed. Is it 56, 57, 58, 59? Section numbers are there. When can a private person arrest? All of these types of questions do come from this area. So I hope this is clear. There were no doubts in relation to this lecture, and the leftover portion of today's class we'll cover in the next class. And let's meet in the next class then. Thank you and bye-bye.